Hello, and welcome to another episode of AEM's Talking with the Experts. I'm Mike Nichols, your host and AEM's content and social media manager. And in today's episode, we're talking about new climate disclosure rules that were recently released by the U.S. Securities and Exchange Commission. And plus, we'll also be touching on some climate rules that were also released by in California as well. So joining me to provide some insight, we've got Coy Garrison. Coy is an attorney and partner at the international law firm of Steptoe LLP. His practice areas include regulatory compliance and policy, as well as climate and sustainability. And before joining Steptoe, he served almost 9 years as an attorney at the U.S. Securities and Exchange Commission. So, right guy to be talking to today. Before that, he was also a staff attorney at the U.S. Court of Appeals for the 4th District. So, Coy, thank you for joining us today. I really do appreciate you taking time out of your schedule to be here.
Yeah, thanks so much for having me, Mike.
Yeah. So before we get started, since we are talking about some regulatory matters, I do need to just insert a little disclaimer, right? We're going to be having a very general discussion suited to a broad audience, not pretending to know anybody's individual circumstances. So none of what we're saying today should be construed as legal advice for any specific person or entity. And with that disclaimer out of the way, should we go ahead and dive into our discussion, Coy?
Yeah, sounds like a plan.
Great. So maybe you could get us started with maybe just a high-level overview of the new rules. I mean, when are they supposed to take effect? And when would companies need to start complying?
Yeah, sure. So from a timeline perspective, the largest companies will have to start making disclosures in fiscal year 2026. Now, what that means, though, is that they'll have to start collecting information to make those disclosures in fiscal year 2025. So don't be too fooled by the timeline. There's really not much time before this kicks into place, and then as you go down the line, the smaller companies on a tiered basis will keep coming in. And I think it's important to remember just broadly when thinking about this rule is, if you're just reading at a high level what's in the papers and your takeaway might be, well, it sounds like scope 3 emissions is no longer included in the rule. And so it sounds like it's just been pared way back. The rule must not be that bad. I really want to just drive home the point that this is a massive new undertaking for public companies to comply with this new climate-related information disclosure rule. Even with the pared back nature from the proposal from 2 years ago, this rule is significant in its scope. It requires everything from climate-related risks, in addition to what are the actual material impacts on your business strategy, your financial condition, your results of operations. What are the governance factors here? So how does your board of directors oversee this risk? How does your management assess and identify these risks? Detailed disclosures on all of these points are required. If you're looking at transition plans, at scenario analyses, if you have targets and goals in the climate-related area, there are detailed prescribed disclosures that are required here. We haven't even gotten to the greenhouse gas emissions, right? And then you have all of those. You have financial statement metrics that have to be disclosed. It is a really, really heavy undertaking. So don't be fooled by the top headline that scope 3 is not included. There's a lot of disclosure that's required here.
That's some good insight, Coy. Appreciate that, driving that home. I do want to dive deeper into some of that. But before we do, I mean, there is this big pink elephant kind of hanging out there in the room. As I understand it, a bunch of parties, they've filed various lawsuits from both sides, saying it's too burdensome, saying it doesn't go far enough. And the U.S. Court of Appeals for the 5th Circuit, they even granted an administrative stay for a while, right? I think that might have expired. But, tell us a bit more about those challenges and what that might mean for our listeners. I mean, does it make sense maybe delay preparations until you know more about how the challenges are going to shake out?
Sure. So let me give an overview of where the legal challenges are, because it's complicated and unusual to see so many, right? So I believe 9 different litigants raised concerns with the rule in 6 different Circuit Court of Appeals. The SEC then saw this landscape and saw that they were being challenged from all angles to many different circuits and said, you know what, I'll take my chances with one circuit. And so they utilized a procedure where they can consolidate all of these cases into one circuit court, and it's done by a lottery process. It's actually a lot like the lottery that you and I might play and hope for the winning numbers at night. They put each circuit's name on, like a ball in a cage. There were witnesses and everything to make sure there was no tampering, and the court's clerk pulled out, and voila, the Eighth Circuit Court of Appeals won the lottery to hear all of these appeals. With that being said, this circuit, as you mentioned, had issued a stay on the implementation of the rule. The Fifth Circuit vacated that order after the Eighth Circuit got hold of it. Where we stand today on April 4th is those parties that originally sought a stay on the rule have requested the same stay based on the same briefings. The Eighth Circuit is assessing that request, and other parties are now requesting a stay. So we will see. We don't have an exact timetable for when the Eighth Circuit will rule on that, but obviously that's just the first step. Regardless of whether the rules are stayed or not, the Eighth Circuit will order. Provide an order with detailed requirements for briefings, and we'll know more in the coming weeks and months. But why does all this matter, right? So why should you put your head in the sand and say, well, let's just see how the legal incidents play out before we start complying? And I just strongly caution against that, in the sense of these rules have such a short time because of the volume of information you will be required to disclose on a relatively short timeline of beginning of fiscal year 2026, covering information in 2025 for the largest companies. You don't have enough time to put policies and procedures into place if you wait too long. And so everyone I've been talking to had been suggesting that really now is the time to kind of do a gap analysis of what are you doing already versus what does will require, and start mapping out what you would need to do to get from point A to point B. And I think everyone will differ from that point of how they need to proceed on their facts and circumstances. But I think it's a prudent course of action to take, regardless. And as you said, no one knows how these challenges are going to play out, right? I share many of the concerns raised about the statutory authority of the SEC to issue these rules and the like, and I think there will be undoubtedly arguments about whether the SEC is exceeding its statutory authority there. The major questions doctrine is a term that's been thrown around a lot, which I'm sure there will be arguments made under, challenges under the Administrative Procedure Act and the like as well. And then, of course, you have folks on the other side, like the Sierra Club, that challenged and said, you know what, the proposal covered scope 3. We don't think it was reasonable to take out at the adopting stage. So you see the challenges run the gamut, but I think regardless of where we are right now, just given the level of uncertainty, but then also the level of information you do have to comply with, it makes a lot of sense to get started now.
Yeah, that does make sense. So as I said, I'd like to dive a little bit deeper into some of what you started explaining. Probably the place to start is, the rules pertaining to the disclosure of greenhouse gas emissions. Those seem to be getting most of the attention, I think.
Yeah. So for greenhouse gas emissions, the final rule requires if materials scope 1 and scope 2 emissions data. Now, this is required for essentially the larger companies in the public company space. We'll bore you with the details, but the large accelerated filers, and then if you're not a large accelerated filer, everyone except for smaller reporting companies and emerging growth companies, right? And happy to talk offline with anyone if you want to figure out where you fall within that, or just interested in the securities law thresholds for sizes of companies and the like. But essentially what that means is for the largest companies, they're going to have to determine if their scope 1 and scope 2 emissions data is in fact material. And if it is, then they're going to have to disclose that expressed in the aggregate, to the extent that any constituent gas in the individual is material, then they have to break that out. But otherwise, they're going to have to talk about the description of the methodology used, any significant assumptions used in calculating that methodology, the operational boundaries that they're using in determining this are going to have to be disclosed. And of course, one of the interesting things is the timing aspect of all of this, right? So a lot of commenters wrote in and said, we can comply with the emissions data, but it's going to be very difficult to do that on the annual reporting for financial information timeline, that it's usually not ready until later, and it's just too much information to prepare in a tiny amount of time. And this was one of the areas where the SEC actually said that makes a lot of sense. And so companies are allowed, when they file their annual report, to forward incorporate by reference this information in their second quarterly report, right? So it gives them a little bit more time to collect this information, to make it go through the processes and everything. It's worth noting that assurance is going to be required on the emissions reporting, right? So you're going to have a expert look at the greenhouse gas emissions reporting and sign off on it. And there's two different levels that would be required over time. It would start off with limited assurance and then reasonable assurance. And the best way to maybe think about that is limited assurance is more of a framed in a negative way, right? I was like, there's nothing that we have seen as the assurance provider that would suggest there is a material emission here, right? And then a reasonable assurance is more affirmative. It's saying, no, we have looked here and this is materially correct in our opinion, right? So that higher level, that reasonable assurance, doesn't really exist today in greenhouse gas emissions reporting and the like. So I think the SEC, in the acknowledgement of that, has given a long runway to allow for the standards to kind of get up to speed on that, and for attestation providers to get comfortable with that, to get companies comfortable with what exactly they're asking for here. And it's definitely an area that's going to evolve in the coming years, but an important one, because that's not only does it add a new intermediary into the process, but it obviously adds complexities and costs involved as well into the reporting process.
Great, Coy. That's really helpful clarification. Appreciate that. Let's switch gears a little bit. The rules I think that probably should be getting more attention than they actually have been. Those are the ones that are pertaining to the disclosure of climate-related risks. Maybe you take us a little deeper into those.
Yeah. So it's funny. Climate-related risks is really like the building block of this entire rule, disclosure rule, right? And so and the starting point really is, okay, do you have any climate-related risks that have had or are reasonably likely to have a material impact on your business strategy, on your financial condition, or your results of operations, right? So that's a starting question. And then you say, okay, if I do have one of those climate risks, there's all this new information I need to start providing. So including really drilling down and identifying what the type of risk is. So the rule walks you through, is it a physical risk or is it a transition risk, right? If it is physical, is it acute or chronic? Is it simply a one-off weather event, or is it something that's more sustained over a period of time of temperature changes based on a number of different factors, right? For transition risks, right, this refers to the idea of if we're moving into a more carbon neutral future, are there regulatory, legislative, policy-driven changes that you are reacting to as a company, right? So, I think, so regardless of whether there's a climate-related risk that directly impacts you in your properties, you still may operate in a region that is undergoing a transformation that would require you to change the way you conduct business. And so that's all the starting points. And then once you get that, then you actually have to disclose a lot of information about the actual impacts of these climate-related risks on your company, and you start looking at, okay, are there any expenditures for mitigating or adapting to these risks that you need to report? Do you have transition plans? Do you use scenario analyses? Do you have an internal carbon price that you use? All these things start kind of cascading and building upon one another, and And so I'll stop there, but suffice to say, climate-related risk itself is like the original building block, and then you just keep going down this laundry list of items that you may have to include more and more disclosure on.
Oh, that makes sense. That does. I'm obviously not the legal expert you are, Coy, but so maybe we could break this down maybe into some concrete examples, help a layman like myself understand a little more, right? So, suppose I run an energy utility with electrical lines running through the area with elevated wildfire risk, or maybe I've got a large outdoor workforce operating at sites that are known to experience a mixture of severe storms and lightning, maybe dangerous heat and cold. Take any of those examples. How would all this factor into my climate risk disclosures, right? And how much would I need to say about what I'm doing to mitigate those risks?
Yeah, so let's just take the wildfire risk maybe as an example, right? So I'd say your very first starting point is what is your company's risk management strategy for identifying, assessing, and managing climate-related risk? Because you have to disclose that. So that's a starting point, and then assume put put that risk through that process. However, that risk got communicated up and throughout the entity, the determination throughout that process would have to be made: is this material to the company, right? Would a reasonable investor find this information important to an investment decision? Does it substantially alter the mix of available information, right? And assuming it does, well then, okay, we're off to the races on all the different disclosures you have to talk about this wildfire risk, right? So um, first you have to kind of define it, like we were talking about. Is it a physical risk, a transition risk? Well, okay, it's physical, and then the question is going to become acute or chronic. It's going to depend on the context, right? I mean, do you suffer a lot of wildfires in the area that have that you perhaps are liable for or under legal jeopardy of being liable for? Is it a new risk based on an acquisition you just acquired in a certain region or anything, right? I mean, these are all the different types of questions you're going to have to think about. Perhaps you operate in a jurisdiction where there's a lot of legislation about assigning liability in this context. Well, that's going to kickstart its own disclosure obligations. You're going to have to address that. And how does that impact your company? Um, I think you really then would start saying, have to drill down on what is the material impact of this wildfire risk on your business strategy, on your results of operations, your financial condition. I think companies are generally familiar with doing that type of thing already in the management's discussion and analysis. And if the wildfire risk is something that's financially material today, they may already be doing that. But for, perhaps for other companies that it hasn't been financially material to consider these things, they'll have to start going through this process in a different way. Any expenditures that you've incurred to mitigate or adapt to this would have to be discussed and disclosed, segregated out, right? It wouldn't be able just to be wrapped up in a larger line item in your financial statements. Um, Everything from the way that your board how does your board consider this risk? Does it talk about it at meetings? Who talks to them about it from management? On the management side, who's responsible for this type of thing? What are their credentials? These are the types of disclosures that you're going to have to start complying with. So you can see how it snowballs pretty quickly, right? And you really got to think it through from many different angles.
No, that's really helpful clarification, Coy. I'm going to throw a kind of a ringer at you. So a lot of what we're talking about right now, we're talking about, what are the legal requirements, right? So, but I read in Forbes, and I'd love to get your perspective on this, right? They're saying that, going through this process, there's actually, there's potential for some upside for some companies too, right? It's not just legal onus. Yes, it might give you headaches. It might keep you up at night, but, there's opportunity for competitive differentiation, maybe potential improvements in operations that could result in cost savings. Any thoughts on that, or do you want to stay limited to the letter of the law here? Up to you.
Well, I think every company is going to see this differently and approach it differently. So, right, so I leave it to the individual facts and circumstances of companies that some have cared deeply about this issue for some time and put in a lot of time and effort into distinguishing themselves, and so they may view this slightly differently than others that maybe haven't been focused in on it, and some others may just view this as a simple cost expense, but it's a burden and the like. I think it's um, I'll leave it to each individual facts and circumstances of the company to address.
That's a fair answer. That's a fair answer. So returning our focus back to the law, I mean, obviously there are going to be some areas that are subject to interpretation. I think you've already touched on a couple of those during our conversation, but maybe you could highlight some of those key open-ended requirements in the rules and explain what that means for people's compliance efforts.
Yeah, I mean, I guess I would start it, but like, look, nobody has provided this information to this level of detail in SEC reporting thus far. So everything is going to be a steep learning curve, and everything is going to be open to interpretation, right? This is a new thing for everybody. With that being said, I mean, there's a few big ticket items I think that people are thinking about. Um, One of them really is the SOAP 3 information, interestingly enough, right? And we all know that it was dropped from the final rule. But there's some potentially confusing instructions in the rule, right? That if you have specific targets or goals that are material to the company, you're supposed to disclose that. And so then there's this open interpretive question of, well, what happens if a company has set a scope 3 emissions target because they believe it's important and they believe it's material, but the SEC rule doesn't expressly require that disclosure? Do you still have to provide that information under the targets and goals, right? So that's one open kind of question that folks need to work through and think through on each individualized basis. Um, we talked about it a little bit already, but the attestation requirements, exactly what that will look like and how the engagements between the companies and the attestation providers, that's going to be an evolving process. The standards that they use, that's going to be an evolving process. And I think it's just going to take some time. But like I said, I mean, literally everything in this rule is a little bit of an open interpretive question at this point.
Yeah, that makes sense. I think one of the things you've driven home is this is going to have a pretty big impact on a lot of companies' financial reporting or annual reporting. But one area I want to ask you about is you look at a lot of big corporations, and a lot of them are already doing some form of voluntary climate disclosure. So if we just think about that subgroup, I mean, how likely are the new rules to affect them, or is it just going to be like business as usual for them?
Yeah, no, I think the rule will have a significant impact on them. I think it's going to be a very costly new rule to comply with, right? Because to your point, a lot of larger companies already provide voluntary climate-related information in their ESG report or their sustainability report. But there's a big difference in providing that information on a voluntary report and then an SEC filing, right? Um, if you're outside of the SEC filing, you're not subject to your disclosure controls and procedures, your internal controls over financial reporting, all of those robust risk management processes that have been put in place that ensure that information is reliable, consistent, all that stuff. It doesn't typically cover information in the sustainability report. And so now it will. So that all that information has to be filtered through that system. That's going to take time. That's going to cost money. That's going to take personnel. And companies will take on more liability for the disclosures that are in SEC filings. So rightfully, they'll want to take more time to consider that information. Maybe the only other point I'd raise on this is that, a lot of companies in voluntary reporting uh, get to pick and choose what metrics they put in there, what they disclose for whatever particular reason. That's, so even if you have experience reporting under the TCFD, uh, reporting under the TCFD voluntarily is different than reporting under the TCFD as interpreted by the SEC and with the SEC as a regulator knocking on your door asking you information about, did you disclose exactly the way we asked you to, all that type of thing, right? So it's just a little bit of a different ballgame.
Oh, that makes sense. So, Coy, this has been a great conversation, very eye-opening for me. But I do want to be respectful of your time. So, to wrap things up, are there any final thoughts you'd like to leave our audience with?
I just think you want to drive home that this is a serious expansion of the disclosure obligations under the SEC rules, and so with that in mind, despite the legal uncertainty, and there's plenty, we will learn more in the coming months about how that is going to go. But it makes a lot of sense now, I think, for companies that are involved in this to be doing that gap assessment, to be starting to think about how do you connect the dots of filling the gaps of where you're maybe short on compliance or the like. And just keeping in mind that the SEC rule is different than other reporting regimes, right? It's different than the CSRD. It's different than California. So if you have a system in place to comply with one regime, it doesn't necessarily mean that you're going to be compliant with the SEC regime. So really thinking that through and starting to map everything out now makes a lot of sense.
Thanks, Coy. That's some great insight. And once again, thank you so much for taking time out of your schedule to be here. Really do appreciate it.
Really appreciate you. Thank you.
And thanks all of you for tuning in. Hopefully you found today's conversation to be as thought-provoking as I did. Maybe you have some new questions to raise to your own counsel. Either way, no matter what your opinion of them might be, these new climate disclosures are going to be a game changer. And the time to start thinking about compliance is now, not next week, not next month, but now. So until next time, this is Mike Nichols for AEM and for Talking with the Expert.